Howdy, y'all. This is Paul, the Redneck Thinker. What we have here is a channel to communicate. I want you folks to be thinking by the time you leave my videos. Why? Because I'm tired of people talking via what other people tell them to think. So, watch my video and enjoy the chance to think for yourself. Oh, and if you don't mind, like, subscribe, comment. And I've got a link tree down below that's got my social media, and it has my Patreon if you want to help out. Thank y'all. People seem to take what Aldo Di Ballardino said about the grand jury as controversial. People are even saying that it's cause for him and the Peacemaker Sheriff movement to not be taken seriously and that it's dangerous. We're going to examine things about the grand jury because I'm wanting you, as my listeners, to think about the grand jury process in America. I want you to think about this. I don't care what political spectrum you are on. I want you to think about the grand jury. Few people actually do, but I want you to listen to what evidence I bring you, and I want you to make your own conclusion. Do I have a conclusion? Yes, I think that the grand jury system in America has way too many things wrong with it. But I'm going to give you evidence. I'm going to give you some facts that then will lead you to make your own conclusions. My conclusions are my conclusions. Everybody has an opinion. But to have an educated opinion is far more important. Far more important. So, we're going to discuss the grand jury, and we're going to listen to some of the experts. Well, I'm going to read you off what the experts are saying about this. So, let's get headed into it. Okay, I'm going to go over a couple of things that I got out of the book called The Gotti Wars. This was written by John Gleason. He was an AUSA for quite a few years. He was the AUSA that finally took down John Gotti, thus the title, The Gotti Wars. And he was also a federal judge for many years before he wrote this book. Now, the first thing I'm going to tell you from this book is a quote. It's a long one. The grand jury occupies a unique role in our federal criminal justice system. Rooted in centuries of Anglo-American history, the Fifth Amendment to the Constitution says that no one can be required to answer to a felony charge, that is, be bound over for a trial before a petit jury like the ones we see on television, except upon indictment by a grand jury. Ideally, then, the grand jury serves as a kind of buffer between the government and the people. But in reality, it's no buffer at all. A grand jury presentation can consist entirely of information that would be inadmissible at a trial. A prosecutor can use illegally obtained evidence to get an indictment, and if the prosecutor has other evidence in his or her possession that indicates innocence, the prosecutor can withhold it from the grand jury. The prosecutor need only establish probable cause, not proof beyond a reasonable doubt, that the target committed the crime. More important, there's no one else there but the prosecutor and the grand jurors. The target and his lawyer aren't even allowed in the room, let alone permitted to question the evidence. The grand juries don't act as a check on prosecutors, don't mean they're useless. They're enormously useful to the prosecutors themselves, and indeed are one of the most powerful tools they possess. A grand jury has nationwide subpoena power and can summon witnesses and documents to the grand jury room. Guided by the assistant U.S. attorneys who bring their investigations to them, the grand jury's awesome power become their powers. And because everything grand juries do is shrouded in closely guarded secrecy, those subpoenas, which are prepared by the prosecutors and served by federal agents, are ominous indeed and strike fear in the hearts of those who receive them. Did you get that? This is where how the prosecutors act can determine who gets sent to a trial, whether they're indicted or not. In another part of the book, he was talking about when he was getting everything ready for the second Gotti trial that he participated in, the one in which he did get the conviction. He had gotten in a new AUSA. Well, that new AUSA was told, get rid of the cases that you have, meaning to get them quickly convicted or whatnot. But instead, he went to a grand jury and said, no bill the charges. What a no bill is, if you have a pending criminal charge against you, it may seem strange if, while waiting for an indictment, you receive a no bill. The legal definition of this term involves a grand jury noting that there is not enough evidence to indict you on alleged crimes, or the prosecutor determining the same and not pursuing your case any further. Think about that. How many people have you've heard, oh, the grand jury didn't indict, even though it was pretty clear that there was evidence. But if the grand jury was told no bill it, guess what? So this is the first bits of information that I wanted you to know about. And this is from a really prominent prosecutor. Okay, so let's go over kind of the history and how it's changed. At the time of the founding of the United States, grand jury indictment was required for almost all prosecutions, and juries rendered the final verdict of almost all criminal and civil cases. The Fifth Amendment of the Constitution reads, no person shall be held to answer for a capital or otherwise infamous crime unless a presentment of indictment of a grand jury. Okay, I'm going to be using Wiki for this. There's so many different pages, and all I've read, this is actually pretty concise with what I've read from other pages. In the early decades of the United States, grand juries played a major role in public matters. During that period, counties followed the traditional practice of requiring all decisions to be made by at least 12 of the grand jurors. E.g., for a 23-person grand jury, 12 people would constitute a bare majority. Most criminal prosecutions were conducted by private parties, either a law enforcement officer, a lawyer hired by a crime victim or his family, or even a layman. A layman could bring a bill of indictment to the grand jury. If the grand jury found that there was sufficient evidence for a trial, that the act was a crime under law, and that the court had jurisdiction, it would return an indictment to the complainant. The grand jury would then appoint the complaining party to exercise essentially the same authority as state attorney general has, that is, general power of attorney to represent the state of the case. The grand jury served to screen out incompetent or malicious prosecutions. Now, I don't care what political party you are, you know that there are plenty of malicious prosecutions that happen nowadays on all sides. Don't say that there isn't, because if you're a Democrat, I can guarantee you can find several. If you're a Republican, same thing. The advent of the official public prosecutors in the latter decades of the 19th century largely displaced private prosecutions. While all states have provisions for grand juries as of 2003, today approximately half the states employ them. And 22 states have provision to prevent the abolition of grand juries by legislature or courts as of 2003. 6 states, Oklahoma, Nebraska, New Mexico, North Dakota, Nevada, and Kansas, allow citizens to circulate a petition in order to impanel a grand jury. That is something that Aldo D. Bellardino is wanting. Well, an American federal grand jury has from 16 to 23 jurors, with 12 votes usually required to return an indictment. All grand jury proceedings are conducted behind closed doors without a presiding judge. We just heard that from John Gleeson. The prosecutors are tasked with arranging for the appearance of witnesses as well as drafting the order. Okay, all this was covered by John Gleeson. So, that's more knowledge about what's going on. Now, we're going to use, this is from something called Nolan Center for Justice. It's conservativejusticereform.org. Okay, I know many of you are going to go, well, it's conservative. I don't care. This actually makes sense, and I want you to listen to it. Because, I'm sorry, if you're liberal, actually listen to it and tell me if it doesn't make sense to you too. A grand jury is meant to be used to decide if there's enough evidence in a case to bring it to trial. To fulfill this purpose, a grand jury should have no bias and be made fully aware of all evidence. But this is not the case in most states. The Supreme Court has not yet recognized grand juries as a requirement of constitutional due process. As a result, grand juries are regulated entirely by the state, and half the states in America do not even require a grand jury before a case goes to trial. States have almost complete control over the entire grand jury process, causing a number of problems. For example, the pick-a-pal system used in many states allows a judge to appoint 5 jury commissioners who recruit or pick whomever they wished to serve on the jury, even if it means choosing their pals. Unsurprisingly, studies have shown that this system increases the chance of a favorable outcome for the state, as well as a higher chance of indictment. The fact that the jury was chosen by people connected to the court rather than at random demonstrates its bias. The evidence presented in criminal trials are bound by certain rules of admissibility, but most grand juries function as an evidence free-for-all, allowing the state to present evidence that won't be admissible in a criminal trial down the road. Hearsay, for example, is permitted. If this evidence can't actually be used to find someone guilty, then why is it allowed as evidence to determine an indictment? This not only wastes time and taxpayer money, it also unnecessarily destroys lives. Many states give prosecutors an unfair advantage in grand jury proceedings that they would never have in trial court. In most states, defense counsel isn't even permitted in the grand jury room with their client. And the states that do permit their presence forbid them from addressing the jury. If everyone has a right to counsel, then why is it that counsel is not allowed to be present when their client is up for indictment? Prosecutors also have the advantage of being able to call for a virtually unlimited number of grand juries, meaning that even if a grand jury decides that the state does not have enough evidence to make its case, a prosecutor can simply keep calling grand juries until he or she obtains a desired outcome. A subsequent jury should, of course, be used when new evidence is discovered. The whole point of grand jury process is to determine whether enough evidence exists for a trial. But without new evidence, the prosecutor is merely attempting the same argument with different people in order to indict someone that has already been released by another jury. This is an unfair abuse of prosecution power and should be ended. A grand jury should be a requirement, but prosecutors should be required to use it correctly. The judicial system is meant to protect people and keep them innocent until proven guilty. All these problems within the grand jury system do the opposite and leave the accused feeling hopeless. So there's more evidence for you. Now, you, as a person who is interested in hearing about grand juries, I just presented you a bunch of evidence, like a grand jury would have. Only, I told you where it came from. I think I did a decent job of giving you all the facts that I could give you. I'm sure there's a lot more that I could do, but this is not a video that I want to have to be a massive long video. I want you to think about what I just presented to you. Heck, I want you to write down in the comment section what you think about all of this. I want your opinion. I want to know if you think that the grand jury system needs some fixing. I will tell you this much. I want it to be protected. I think that we need to no longer allow prosecutors to do the things that they do with it. I think that it's a great tool. I think that most prosecutors don't use it for corrupt purposes. but there are some that do. And let me tell you, it swings both ways. There are conservative and liberal prosecutors that use that to go against who they see as their enemies or whatever. I want you to think about this. I honestly want you to think about this. I don't care what your political affiliation is. I don't care what your political philosophy is. And yes, that is two different things. I want you to honestly consider what I just told you. I want you to do your own research if you can and tell me what you think we need for the grand jury, whether it's been co-opted or not. I want you to think about this, and I want you to join with me in seeing about what we can do to fix it. This has been Paul, Redneck Thinker, and that's something that I just gave you to think about. Y'all have a good day now. Bye. Folks, I just want to say thank you for listening. I want to thank you for taking your time. I want to hear what your comments are about what you think on this topic, because your comments are what's important, not necessarily mine. I don't care if you're Republican. I don't care if you're conservative. I don't care if you're liberal. I don't care if you're Democrat. I want to hear your opinion on these topics. I want to thank you yet again for listening to my video. Like, subscribe, and all that other hoopla. This has been Paul, the Redneck Thinker. Y'all have a good day now. Bye.